Hello, everyone, and welcome to Employment Matters, a podcast brought to you by the Employment Law Alliance. I'm Peter Walsh, your host for this podcast on sexual harassment among the global workforce. For those not familiar with the ELA, we're the world's largest network of labor and employment lawyers with members in more than 100 countries, all Canadian provinces, and all 50 states. And we offer podcasts, webinars, and other important content like this to provide practical information to businesses all around the world. Today's topic is based on a global survey recently conducted across our organization, with participation from close to 800 lawyers in more than 100 countries. And in this survey, we asked them to share their observations on the challenges their clients are facing with regard to sexual harassment in their workplace, as well as provide us with some of the important advice that they're providing to clients in an effort to help them manage this issue. Today, we'll address the first question posed to our members. How seriously are your clients taking sexual harassment in the workplace? Well, the results of the survey provided some really important insights, with 51% of our members stating that their clients do take sexual harassment very seriously. However, the other half of those responding felt their clients really needed to take this more seriously, or frankly, they just didn't take it seriously enough. Let's join a few of our ELA lawyers from around the world to hear their comments on this question. And let's kick it off beginning with our members from the North American region. Let's start our discussion with Jeff Palomar from Manitoba, Canada. Jeff, how seriously is sexual harassment taken in your client's workplace?
Pete, thanks very much for this. Like most complicated issues, there's good and bad to everything. I'm kind of an optimist, so I'm going to start with the less good stuff, if I can put it that way, and end on a more positive note. Canadian Lawyer has reported recently that 94% of Canadian executives are saying that sexual harassment is not a problem at their companies. Yet 50% of Canadian women say they have, in fact, been sexually harassed at work, and 28% of those say this was non-consensual touching. The thought of a lot of those people who are in the know on these things is that these are solid examples of a head-in-the-sand type of outlook on the problems are much, much greater than being reported and much, much greater than being recognized, unfortunately.
Thanks for that, Jeff. Ashley, let's go to you in Ontario. What are your thoughts on the subject?
Although I do think that we have seen an increase in the degree of seriousness as well as the level of responsiveness that our employer clients are bringing to bear on complaints, allegations, and incidents of sexual harassment in the workplace, which I think is in large part a very positive development. And I think that there have been a number of factors that have influenced that sort of increasing scrutiny and seriousness that's being brought to bear on this workplace issue. This is a matter that has to be taken seriously, and that is, of course, also playing out in the court of public opinion when we see movements like the Me Too and Time's Up movement that have certainly raised public awareness about sexual harassment. And so I think that all of these things combined have really prompted employers to be more reactive. We're seeing that reactivity and responsiveness play out in the type of advice that our employer clients are seeking from us. So looking for advice now not only with respect to how to conduct an appropriate investigation or respond to complaints of sexual harassment, but seeking guidance around what appropriate discipline or penalties might be where a complaint has been made out, and also then looking more holistically for guidance around best practices to manage other elements of the business.
Lastly, let's move over to Bruce Cross from Alabama. Bruce, tell us a little bit about your sense of how we address this topic.
The kicker is, of course, what is serious by your terms. To give you some statistical background, in fiscal year 2017, the EEOC received about 7,000 claims of sexual harassment, and they amounted to about $46.3 million in monetary benefits for victims of harassment. Now, that does not count anything that would be litigation related beyond the settlement and charges. Also, statistically, Fortune 500 companies, they've found, lose a combined estimated $5 billion a year from lower productivity, employee turnover, poor morale, and legal costs, all due or related to sexual harassment in some form or fashion.
I'd like to jump over to a few of our friends reporting in from Europe, and let's start with Annabelle. Annabelle, if you would, please share your perspective from Luxembourg.
Sexual harassment remains a very subjective notion under Luxembourg law. So, and Luxembourg case law considers that it belongs to each individual to determine what behavior he wants to accept, what conduct he considers appropriate or not. So, Sexual harassment must be perceived as offensive or undesirable by the person being subject to it. And if this person feels embarrassed by the unwanted sexual attention, this behavior shall be considered as sexual harassment under Luxembourg law.
Thanks, Annabelle. And now to Oti, our Finnish member. Oti, if you would, what are you seeing happening in the Nordic region?
This sexual harassment, it is taken more seriously in Finland, but according to the recent statistics in Finland, there are still, especially young women, they experience sexual harassment at work, and this is based on the statistics during the last 2 years. Most of the cases are not reported to the employer, and that is a big issue. Nearly 60% of the cases are not reported. The liability to pay damage compensation is one option, and in serious cases also criminal liability is possible, and the criminal liability could be against supervisor and director, so it's personal liability instead of the company's liability.
And finally, to Alberto from Italy. Alberto, what's your perspective on the topic? Specifically, let's talk a little bit about the nuances between what's considered harassment versus a compliment.
Generally speaking, a comment regarding body part of a female worker could be considered sexual harassment, provided that the comment or the compliment is unwanted. This is the real difference between, let's say, a compliment, a nice compliment, or a sexual harassment. It's the perceiving of the approach by the women specifically. So the answer is, honestly, it depends. There is no code determining which is a sexual harassment and which is not. It's a case-by-case evaluation.
Well, thanks, everyone. I appreciate that. Now let's move over to the Middle East Africa region. Lusanda, what's your experience been in South Africa?
I think sexual harassment is taken very seriously in clients' workplaces in South Africa. I think part of the reason why it's taken seriously is because our law takes it seriously. Our law takes it seriously both in terms of our Employment Equity Act that makes discrimination unfair on some listed grounds, and one of which is gender and sex. And also we have a specific code on sexual harassment. So I think because our legislation takes sexual harassment seriously, the workplaces also take it seriously. And in addition to this, in South Africa, not only is it problematic in relation to the employee if they are found guilty of sexual harassment, but our law also places specific responsibility on the employer to make the workplace safe for other employees, and it has direct consequence for employers who do not do this.
And from Latin America and our member from Ecuador, Javier, where is your firm seeing most of the activity on this issue?
How serious actually the treatment of sexual harassment matter has become, besides the poll, we can say like at least 30% of our practice clients have asked us for guidance on internal regulations, on investigation, on internal procedures, and most of all, harassment and sexual harassment in-house trainings. And even multinational clients that have had already worldwide internal policies about it have asked us to localize or adopt the policies to local legislation.
And finally, let's go to Sarah Clark from Australia. Sarah, can you share your thoughts on the rise in the Me Too movement and the financial impact it's had on companies in Australia?
I think in recent times, and similar to other jurisdictions, there's been a number of cases which have shown the importance of taking these matters very seriously, not only from a reputational point of view, but from a cost point of view. We've seen a significant increase in the award of damages in sexual harassment cases in recent years, and perhaps also spurred on by the Me Too movement in the last 12 months. So look, I think businesses now are really taking these matters very seriously. We've also seen an increase in clients engaging external investigators to look at these matters instead of doing them internally themselves. And I think that says a lot about how seriously they're taking these matters, ensuring that, you know, the person who is investigating any of these complaints has the requisite expertise and skill base. I mean, look, it is concerning. There are surveys conducted by our Australian Human Rights Commission, and they're run about every 4 to 6 years. And there's certainly still evidence of sexual harassment occurring too regularly in certain industries. I know in particular in our hospitality and retail sector, there was an astonishing number of people, in fact it was 89% of respondents to a survey in the hospitality industry who had said that they had been sexually harassed in the last 5 years at work, which is an astonishing figure. So there's still a lot of work to be done in certain industries, but in relation to our client base, we're certainly seeing clients taking these matters very seriously.
Join us in our next edition of this podcast series when we'll address the second key question. How concerned are you that the Me Too movement will create a backlash against women being promoted or hired? In upcoming programs, our guests will continue to unpack and discuss this important topic of sexual harassment, as well as address other hot issues regarding bullying, romantic relationships on the job, and other workplace situations that are impacting companies all around the world. On behalf of the ELA and its global membership, we hope you were able to glean some valuable information from today's program. Employment Matters is a podcast brought to you by the Employment Law Alliance, providing global HR legal solutions. For more information on upcoming programs, to listen to the full archive of the program from our library, or to subscribe to the ELA Global Employers Handbook, just visit us on the web at ela.law.